Mr. President, Madam Vice President, distinguished members of the Court, it is an honor to appear before you today on behalf of Hungary concerning the case Obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. Allow us to take this opportunity to express Hungary's commitment to the principal judicial forum of the United Nations that plays a fundamental role in the field of international law. During its 80 years long history, the Court has contributed significantly to the strengthening of the rules-based international order. The increasing number of states submitting their disputes to the Court's adjudication and the unprecedented workload of the Court reflects the trust of states both in the Court's mandate and in the quality of its work. It is of great importance to maintain the confidence in the work of the Court and to abstain from proceedings that may erode that confidence and may create a situation where the Court becomes an actor in an ongoing conflict. The government of Hungary recognizes the importance of the numerous proceedings for an advisory opinion and the potential impact that they have on the prospects for peace and stability in the Middle East. When discussing the issue of the advisory opinion proceedings and the question posed to the Court within the request at hand, one must reflect upon the broader political context, taking into account the dimensions of the Israeli-Palestinian conflict. Although the current proceeding aims to address specific issues of international law obligations with regards to a member state of the United Nations, the pattern of politicization of international judicial fora cannot be disregarded when examining this case before the esteemed Court. Hungary recalls that in 2004, this esteemed Court clearly stated in its advisory opinion concerning the construction of a wall that the resolution of the Israeli-Palestinian conflict can only be achieved through direct negotiations between the parties on the basis of international law and through the implementation of the relevant Security Council resolutions. Since 2004, this original approach has not changed, although numerous aspects of the political context have shifted. The horrendous terrorist attack conducted against Israel by Hamas on 7 October 2023 was a turning point. Hungary strongly condemns these horrific terrorist attacks and calls for the immediate and unconditional release of all hostages. Since then, Israel has been fighting the terrorist organization Hamas with the aim to prevent such monstrous terrorist attacks ever happening again. The evil of terrorists is well shown by the fact that they use innocent civilians as well as education and healthcare facilities, including those associated with the United Nations, as shields. Sparing the lives of both Israeli and Palestinian civilians is of the utmost importance now as well as in the future, with a sustainable peace free of terror. The terrorist attack of 7 October 2023 can also be considered a turning point with regards to the intensification of activities in the field of international law in relation to the conflict, including those of the esteemed Court. We welcome that the esteemed Court has called several times for the immediate and unconditional release of the hostages held by Hamas and underlined that all parties to the conflict must abide by international humanitarian law and international human rights law. We must also note that the proceeding brought before this esteemed Court may directly contribute to the escalation of the conflict. We are of the view that the present and the former requests for rendering an advisory opinion, as well as the procedure initiated by the Republic of South Africa against the State of Israel, may be considered as an interference in an ongoing conflict that does not contribute to the de-escalation and an eventual settlement. It is our conviction that politicization of the court and, in fact, utilization of the court creates new dividing lines and continues to fuel tensions. Hungary has also welcomed the ceasefire agreements related to the hostilities. Unfortunately, the latest ceasefire agreement collapsed in March of this year, leading to an all-consuming high-level conflict. In view of this, Hungary stresses the need for a new ceasefire agreement in order to secure the immediate and unconditional release of all hostages and to achieve a lasting resolution of the conflict through negotiations between the parties concerned. Bearing in mind this broader context, let me now turn to addressing the three main issues that Hungary considers the most important to highlight, as we have also done so in our written statement. Hungary wishes to present issues related to the jurisdiction of the court, arguing that the court should use its discretionary power to decline to give an opinion. With regards to the questions posed to the esteemed court, we wish to present arguments based on the established legal framework regarding the Agreement on Privileges and Immunities of the United Nations, with a particular focus on UNRWA. And finally, Hungary wishes to reiterate its position concerning the context of the present advisory procedure. Mr. President, distinguished members of the court, with regard to the first issue, Hungary duly submits that Article 96 of the Charter of the United Nations establishes the possibility for certain organs of the United Nations to initiate advisory proceedings. In addition, it is necessary to take into account paragraph 1 of Article 65 of the Statute of the Court, according to which the Court may give an advisory opinion on any legal question. The Court was unanimously convinced that Article 65 means that the Court has a discretionary power to decline to give an advisory opinion, even if the conditions of jurisdiction are met. The Court has to take into consideration several aspects when elaborating on the question of whether to use its discretionary power to refuse to give an opinion. As regards the limits of the discretionary power, the Court's jurisprudence is consistent in this regard. Only compelling reasons should lead the Court to refuse its opinion. With regard to the compelling reasons, in the present case, we are of the view that several compelling reasons should be taken into account that individually, as well as cumulatively, may require the Court to refrain from issuing an advisory opinion to the present question. First, in 2024, in another advisory opinion proceeding on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, the Court has already given its opinion with regards to the applicable rules and principles of international law, and expanded on its understanding of Israel's specific obligations. It cannot be disregarded that the advisory opinion of the Court was given on 19 July 2024, merely 4 months before the request of the present advisory opinion was adopted by the General Assembly of the United Nations. Second, a contentious proceeding is currently pending before the Court that also touches upon the specific obligations of Israel. Giving the advisory opinion might essentially prejudge elements relevant to the case brought against Israel by the Republic of South Africa, thus gravely undermining the integrity of the Court's judicial function. We recall the existing precedent for rejecting a request for an advisory opinion based on compelling reasons. The predecessor of the Court, the Permanent Court of International Justice, declined to issue an advisory opinion on the status of Eastern Karelia, a decision that gave rise to the Eastern Karelia Principle. This decision and principle has never been overruled. We know that the Court in its subsequent decisions has always taken due care to demonstrate the factual differences from the Eastern Karelia case when considering the exercise of its jurisdiction. This must lead us to the conclusion that the legal criteria set out in that decision remain authoritative. In the decision not to render an advisory opinion, it was stated, "The question put to the PCIJ was directly related to the main point of the dispute actually pending between two states, so that answering the question would be substantially equivalent to deciding the dispute between the parties." The situation in the present case is strikingly similar, as an advisory opinion rendered will unquestionably influence and thus might potentially prejudge determinations to be made in the parallel contentious proceeding. Third, the question submitted to the court has been formulated in a manner that is blatantly prejudicial and one-sided. The question posed by the request is indeed so targeted at Israel that it proceeds on the assumption that Israel has failed to meet its obligations under international law, without any regard to Israel's legitimate security interests and concerns, or to the obligations of the United Nations and third parties in relation to the very subject matter of the question. Replying to the question would inherently entail an affirmation of the statement in the request. Last but not least, we emphasize that the request would require the court to undertake significant factual investigations and make concrete findings on disputed and dynamic matters, which cannot properly be pursued in the framework of advisory proceedings. However, the advisory proceedings of the court are inherently ill-suited for the fact-specific analysis. Disregarding such analysis may further hinder the legitimacy of the court. Thus, the limitations of advisory proceedings should be duly taken into account by the court when deciding to exercise its jurisdiction. Therefore, we reaffirm that an advisory opinion in the present case would be contrary to the common interpretation of compelling reasons and therefore could have a negative impact on the perceived legitimacy of the court. Mr. President, distinguished members of the court, without prejudice to our firm position that the court should decline to give the advisory opinion, we now turn to the second major issue: the legal framework of the United Nations presence in member states and specificities of UNRWA. Members of the United Nations have assumed voluntarily obligations to enable the UN, its specialized agencies, funds, and subsidiary bodies to fulfill its principal purpose as enshrined in the Charter of the United Nations, namely the maintenance of international peace and security and the peaceful settlement of disputes. The obligations enabling the fulfillment of these peaceful purposes are, as such, neither absolute nor unqualified. The obligations that members of the UN have taken upon themselves are in the Charter of the United Nations, as well as the 1946 Convention on Privileges and Immunities of the United Nations. We have to underline the necessity of the joint interpretation of numerous articles of the UN Charter and provisions of the 1946 Convention. Article 1 of the Charter states clearly the purposes of the organization, and the introductory sentence of Article 2 makes a clear link to the first article. In it, the introductory sentence of Article 2, a distinction is made clearly indicating that obligations arising from Article 1 and 2 are also prescribed for the organization itself. Obligations arising from Article 2 thus have to be interpreted consistently taking into account the actions of the UN, its specialized agencies and subsidiary bodies as well. Thus when paragraph 5 of Article 2 of the Charter stipulates that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter, it is clear that a limitation to this obligation is included. The organization is obliged to take actions in accordance with the Charter. Thus, if actions of the organization were to be found contrary to the Charter, the member in question cannot be expected to give the assistance required by the said article. Article 105 of the Charter provides that the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. This provision is also clearly linked to Article 1 and 2 of the Charter that contain that the fulfillment of the purposes of the organization must be in accordance with the Charter. Article 105 also sets a clear limitation in terms of the extent of the privileges and immunities, making it clear that there is a functional approach to be applied. The obligation of impartiality in the execution of the functions of the organization can be derived from Articles 100 and 101 of the Charter. This obligation is further codified in the staff regulations and rules of the United Nations, including in its core values. Moreover, the duty to act impartially constitutes a fundamental principle of the status of international civil servants. It must be noted that the 1946 Convention has a specific functional approach as laid down in the preamble of Articles 4 and 5 of the Convention. As is customary in international law, privileges and immunities are intended to enable the efficient functioning of actors of international law, in this case the United Nations. The joint interpretation of articles of the Charter, the 1946 Convention, and the staff regulations and staff rules, including provisional staff rules of the United Nations, is necessary. It can thus be concluded that obligations exist not only for the member states, but the organization as well. The UN shall act in accordance with the purposes of the Charter, and this creates a limitation to the privileges and immunities provided to the organization in carrying out its functions. As Resolution 79/232 is specifically focused on UNRWA, observations must be made with regards to this subsidiary body established by the UN General Assembly. Resolution 302 of 1949 did not specifically outline UNRWA's privileges and immunities. It simply called on states to grant the same privileges and immunities as for its predecessor. This clearly means that in order to be able to implement the requirements of the Charter and the 1946 Convention, additional agreements with the host states needed to be concluded. This has in fact become the practice concerning other host states of UNRWA. With regards to Israel, an exchange of letters was conducted on 14 June 1967 between Israel and UNRWA, the so-called Comey-Michel-Moore Agreement. The exchange of letters specifically states that the Israel government will facilitate the task of UNRWA to the best of its ability, subject only to regulations or arrangements which may be necessitated by considerations of military security. Thus taking into account the legitimate security concerns of Israel. The exchange of letters also makes specific reference to the 1946 Convention. UNRWA's failure to maintain neutrality and the involvement of UNRWA staff members in acts of terror undermined its status as a legitimate aid organization. UNRWA's tie to terrorism have become an established fact, particularly following the revelations regarding the involvement of UNRWA employees in the 7 October 2023 attacks. Following allegations that at least 19 UNRWA employees participated in the attacks, the United Nations itself also responded, thus acknowledging the necessity to react to the presented evidence of this involvement. The involvement of UNRWA staff members in acts of terror constitutes a serious breach of the principle of impartiality and the lack of acting in accordance with the principles enshrined in the UN Charter. Furthermore, it is a well-established international norm reflected in multiple conventions and UN resolutions, such as Resolution 1373 of 2001, that organizations are prohibited from providing assistance to terrorist organizations. These facts constitute a ground for the abrogation from the Comey-Mission-Moore Agreement and justify the limitations to the privileges and immunities granted to UNRWA as a subsidiary body of the UN General Assembly. Mr. President, distinguished members of the Court, without prejudice to our firm position that the Court should decline to give the advisory opinion, I now turn to our third and final quarrel. Further elaborating on the introductory remarks, we would like to refer to the broader context in which the request for the advisory opinion was made. It is important to note that Israel withdrew its military presence from the Gaza Strip in 2005. It is the terrorist organization Hamas, which violently took power in 2007, that has been governing the territory, including by way of control over the local economy, policing and internal security, welfare services, tax collection, education, and the media. This request for an advisory opinion cannot be separated from the ongoing conflict, and regrettably, it may only be interpreted as an additional avenue within the conflict. There is a realistic fear that the Court itself is being used as a battleground. As explained above, the involvement of a subsidiary body of the United Nations General Assembly through its staff members in actual acts of terrorism is precisely the reason why there is a need to consider the abrogation of privileges and immunities. Unfortunately, the esteemed Court will implicate itself in matters that unduly politicize the esteemed institution of an otherwise strictly judicial character. Our concern is not in vain. The advisory opinion of 19 July 2024 did in fact become part of the already heated political debate. We firmly believe that the peace and long-term solution of the Israeli-Palestinian conflict can only be achieved through enabling meaningful dialogue between the parties concerned. The proceedings before the Court, due to their highly politicized and divisive nature, further escalate the tensions between the parties. In conclusion, Hungary has in the present statement put forward 4 compelling reasons why the Court should not render the advisory opinion, which has been requested of it. Without prejudice to this request, Hungary has also put forward arguments with regards to the broader political context, which must be taken into account, as well as the legal framework of privileges and immunities of the United Nations and UNRWA. Therefore, Hungary respectfully requests the Court to decline providing an advisory opinion. Mr. President, members of the Court, this concludes my presentation today. I thank you for your kind attention.